Welcome to the fourth episode of Turning Points, GCERF's first podcast series exploring the rehabilitation and reintegration of returnees from Northeast Syria. My name is Basile Ema Ebede, and I am one of GCERF's regional managers. Today, we turn our attention to the legal frameworks shaping the return of so-called foreign terrorist fighters and their families from Northeast Syria. At the heart of this debate lies a fundamental legal question. Does international law create an obligation for states to repatriate their nationals from these camps? And how have different countries sought to navigate the complex challenges that follow, from ensuring children's rights and resolving questions of citizenship to establishing legal frameworks for rehabilitation and reintegration? Today, I am joined by Aoife Devlin, a law graduate who is currently working with a human rights law firm. Aoife supported GCERF's research examining both international and domestic legal approaches to repatriation, including comparative perspectives from Iraq, Indonesia, and North Macedonia. This conversation builds on that important paper, which is available on GCERF's website. Please check it out. On that note, welcome to Aoife to Turning Points.
Thank you so much.
So, through this podcast series, we have heard about the tens of thousands of people still living in camps in Northeast Syria. The European Court of Human Rights referred to the situation in the camps as verging on a legal vacuum. For someone with no legal background listening to this, the obvious question is, surely the law has something to say about this? So, what does international law say about this, and why has it not been enough?
I think for someone with no legal background in particular, the first thing to probably address is that there's two kind of types of international law or areas of international law that are directly applicable to this issue. First of all, we have two UN Security Council resolutions, one from 2014 and one from 2017, that essentially address and are considered legally binding on states on how they are supposed to deal with this issue. That isn't directly enforceable by the UN, for example, on states. So states are expected to come up with their own legislation that is domestically enforceable. Separate to that, we have the whole regime of international human rights law, which is obviously extremely relevant to the interests of the people who are in the camps. Those international human rights principles come from a variety of different legal instruments, such as the International Covenant on Civil and Political Rights and the Convention on the Rights of the Child. In the first instance, individual states adopting domestic law, those laws would be enforceable by those states and their domestic regimes. When it comes to international human rights law, it's more complicated in terms both of how enforceable the principles are, and then particularly when it comes to these camps, whether states have jurisdiction in the camps to the extent that the rights of the people there are enforceable against the states that might owe them those rights.
Thank you. So, the legal foundation exists, but it has not translated into action. Throughout the paper, there seems to be a tension between what international law appears to encourage and what states are politically willing to do. What will you identify as the main obstacles to repatriation? And does your research across Iraq, Indonesia, and North Macedonia suggest those obstacles are consistent regardless of context?
Yeah, absolutely. So I think that the key word, even in the question there, is what is political and what states are politically willing to do. So in terms of the consistency of those obstacles, they have something in common with regard to the fact that they're going to be inherently political. So the decisions, because of a lack of enforceability or the ambiguity surrounding the international legal framework that we just talked about, the decisions taken by states become essentially political and administrative in nature. And so in my research and what I came across in Iraq, Indonesia, North Macedonia, the considerations leading to obstacles were political. Obviously, in each country, they have different politics and different political considerations, and that leads to different kinds of political obstacles. For example, where documents are more of an issue in Iraq, and whether documents issued by ISIS are not considered valid and can have the opposite effect if you're found in possession of those documents. That has a basis in a political challenge, and that creates a different obstacle than, for example, in North Macedonia, where documentation is an issue, but the political consideration could even stem from the fact that they have done great work in leading to the recognition of people returning who are stateless. That creates different political issues where there are stateless people in North Macedonia from different sources. So inherently, the obstacles are political, but the politics depends on each individual situation.
The situation of children, and many of them have spent nearly their entire lives in these camps, is a central theme in your work. What legal and ethical obligations do states have towards them?
Yeah, exactly. So primarily the legal obligations owed to children are contained first and foremost in the Convention of the Rights of the Child, which is one of the most widely ratified international legal instruments that we have. There's 196 states that have ratified it. From a starting point, what it says and what international law says is that the best interests of the child should be prioritised, both in interpreting the different legal instruments that apply, but also in any actions taken which have an effect on the interests of children and the situations where children are involved. Specifically to the issue of children in the camps is that there's the principle that children should always be treated as victims in a situation of conflict, and that's something that we don't always see, particularly in these situations. Furthermore, there's another issue which crops up time and again is when implementing rehabilitation, the importance of avoiding family separation when at all possible. That is a really, really important principle in international human rights law when it comes to children. There's a presumption that it's in the best interest of the child to be with their parents. But for example, part of my research in Indonesia, there was kind of a fear that parents who had been radicalised might then impact their children. So that was leading to family separation. But whether the rights of the child from an international legal perspective, whether that is adherent to international law is probably quite questionable.
So you're mentioning the families. In our previous episodes, we've heard about families without documents, children without legal identity. Your paper goes deeper into this. Why is statelessness such a profound obstacle, not just to repatriation, but to rehabilitation and long-term reintegration?
Statelessness is absolutely everything in this, in my opinion, because it goes back to one of the core points in legal political theory, in that citizenship, on the contrary, is your right to have rights. And everything that's effective and enforceable is derived from your citizenship. And so when you're considering everything that needs to be done, both in terms of return, but then, as you say, rehabilitation and reintegration, statelessness is an absolutely huge obstacle to that, in that in order to effectively rehabilitate and reintegrate, you have to be able to bring people within the remit of the state again, because the state obviously has a lot of work to do in this instance. And you can't effectively, if someone isn't part of the state's framework, it's much, much harder to work with them, particularly with regard to reintegration, to be able to access the state on the same footing as other citizens of the state is incredibly important. And I think we looked at the example that our partners in North Macedonia of saying that you may be able to access education and go to school and learn everything, but unless you have citizenship documents, you can't get the diploma, you can't get the degree. And that's obviously then a massive hindrance going forward. So even if you get a young person, for example, who's done everything right and has gone through all the rehabilitation and everything, those kind of stumbling blocks that are related to statelessness and citizenship can create further problems down the line.
Yes, because if you don't have citizenship, then you don't exist legally.
Exactly. Yeah, exactly.
So one unresolved legal question is whether participation in rehabilitation programs should be voluntary or mandatory. What are the strongest arguments on each side in your view?
It's a really difficult question, isn't it? Because on the one hand, a strong argument for participation not being voluntary is not only do you not want people to feel coerced, because I think common sense would indicate that that's not probably the best start to a rehabilitation process, But where rehabilitation is voluntary, from speaking to our partners, what they were saying is that the most vulnerable people might miss out. So people who are already at risk of falling through the cracks, if rehabilitation is voluntary, it takes effort on the part of a person to engage with services. And so in circumstances where rehabilitation is voluntary, most vulnerable people probably stand to miss out. But on the other hand, what you have in the case for making it voluntary is that in the case of mandatory rehabilitation, there are inevitable human rights and due process concerns. And it's so important that in the case where programs are mandatory, that there are clear protections against arbitrariness. And that's very difficult to do. And even when we describe the situation of the camps as one legal vacuum, if you think about mandatory rehabilitation without checks and balances, that runs the risk of creating another legal vacuum, which obviously is not something that we want.
I see. If another conflict were to generate a new wave of foreign fighters, will you say the legal international system is better prepared today than it was in 2014?
It's an interesting question, and I thought quite long and hard about this one, because given recent world events and the context in which we find ourselves, it's very tempting to say, no, absolutely not. There's so much wrong. We're going down the wrong path. But I think to stop and think about where we were in 2014 with absolutely nothing to address the phenomenon and no principles and no forms of soft law, never mind hard law, it is important, I think, to be somewhat positive and acknowledge that at least this issue has been debated, and there are now people who are trained and have expertise in this issue, and there are organisations like GCERF doing really, really good work in this area. But on the other hand, in terms of capacity, given the extent to which international aid programmes have been eroded away at in the past few years, that's probably a cause for concern, because we know there are a lot of people who know what needs to be done, but the institutional capacity to do so and the political will, especially in a world so focused on security in a more aggressive sense rather than security in a more all-encompassing sense. Like the idea, for example, that of keeping people at bay in camps as a security measure as opposed to rehabilitation. I think political will and institutional capacity kind of point towards the negative answer there. But it is also important to realise where we started from. And in 2014, there was nothing.
In summary, it's not perfect, but at least there's something now.
Yeah, exactly, yeah.
So finally, if policymakers around the world were listening to this conversation today, what is the one misconception about returning foreign terrorist fighters that you will most like to address?
I think, and I touched on it just there in the last question, is that the idea that returning foreign terrorist fighters pose a bigger security threat to the state that they are returning to by virtue of their return rather than being left in the camps. And the idea that they pose a greater security threat returning, I think, is a massive misconception and probably the most important one to address. The whole idea behind this work and the work that so many amazing people are doing is that it's not just about the individuals themselves and their human rights. In that it is incredibly important that these people, and particularly children, are returned because of their own rights, and that's enough of a reason in itself. But from a security perspective, I think it's a massive misconception that returning them is only about them, because it's about everyone and about a safer world. And if the return, rehabilitation, reintegration is done properly, that's a safer world for everyone. And I think that that's really important.
Very, very important words about this difficult matter. Thank you so much, Aoife. We came to the end of our podcast. Thank you so much for the work you've done. This is a critical paper for the matter of rehabilitation and integration.
Thank you.
Aoife, thank you for this important discussion and for highlighting the complexity of the legal questions. surrounding the return of foreign terrorist fighters and their families. As we have seen, the challenges is not simply the absence of legal frameworks, but the difficulty of translating international principles into effective national responses. Responses that address questions of return, citizenship, and rehabilitation while respecting fundamental rights. Understanding these legal and practical challenges is essential to developing approaches that are not only lawful, but also sustainable and effective on the long run. That brings us to the end of this episode of Turning Points. Thank you for listening, and we look forward to welcoming you back as we continue this series. Find Turning Points on Spotify, Apple Podcasts, and YouTube. Share it with your friends and colleagues.